All right. Good afternoon to everyone. We're happy to see that you are all willing to give up your lunch hour to come talk with us about one of the most significant developments in the area of non-compete law in the last few decades, if not ever. I know that the FTC's rule has been at the forefront of everyone's mind since it was adopted last week, and it may have even caused some of you to have trouble sleeping. I get that. It's been my life and Drew's life here for the last year or so. And it makes sense. In adopting the rule, the commission estimated that approximately 1 in 5 American workers, or nearly 30 million people, are currently subject to some form of non-compete restriction. So to say that the rule, if it stands, is a sea change for corporate America, I think would be a gross understatement. Over the last week or so, we've received many questions from both you and your client contacts here at the firm. And as you'll see today, we've endeavored to address most of those in our presentation. Obviously, you'll see we crammed a lot of information into a very small package. And so if there are additional questions, we're going to try to leave time at the end to accommodate those. If we can't, certainly we'll want you to email us those. There's also a chat function in the bottom right-hand corner of the platform that you're viewing this on. You can type questions in there, and we'll gather those, and we'll get back to you with answers offline. Okay, so before we jump into the substance today, I wanted to briefly introduce us, let you know who we are, and give you a little bit about our background. My name is Brodie Erwin. I'm a member of Kilpatrick's Labor and Employment Team in the Raleigh, North Carolina office. I'm joined today by my colleague, Drew Williamson, also on the Labor and Employment Team out of our Atlanta office. A large portion of my practice has been devoted for a while to drafting restricted covenants and advising employers of all sizes in a variety of disparate industries on issues related to the enforcement of those agreements. On the other hand, Drew and I both also regularly litigate cases related to the enforcement of restricted covenant agreements, and we do this in state and federal courts all around the country for our clients. So we have considerable experience when it comes to both drafting non-competes, non-solicits, NDAs, and various related agreements, along with our experience in litigating those in practical real-world settings. So as you can imagine, the events of the last week or so have kept us up, and we've done our best here today to pour all of our knowledge into this presentation for you. So that's who we are. So what can you expect today, right? We're going to, of course, talk about the key elements of the law, of the rule that was adopted. There'll be a little discussion here at the beginning about how we got here with the FTC. You know, the rule actually matriculated out of a long time movement that we've seen across the country to quash non-competes and rule those as a anti-competitive measure. We'll discuss the legal challenges that have already been filed challenging the rule. And then what I'm sure interests most of you the most would be we're going to talk about what you should be doing now to comply with the law while ensuring that your legitimate business interests remain protected. Okay, so what does the FTC rule actually say? The rule provides that it is an unfair method of competition and thus violates Section 5 of the FTC's Enabling Act for employers to enter into non-compete clauses with workers after the rule's final effective date, which was just announced, barring entry of an injunction or a extension or a stay by the court in one of these cases that are pending. That effective date is actually going to be 9/4. So September 4th is kind of D-Day for this if something doesn't change in the interim. The rule, and I'll switch slides here briefly. The rule defines a non-compete clause as a term or condition that prohibits a worker or penalizes a worker for or functions to prevent a worker from seeking or accepting work in the United States with a different employer, or that bars them from operating a business in the United States. Obviously, that's a mouthful, and there's almost a word salad, right? There's 3 distinct clauses there, and if you look at the FTC's guidance for the rule that was issued at the same time, they expressly explained that each clause serves a separate and distinct function. So you look at the prohibit language there. Prohibit applies to the terms and conditions in an employment agreement that expressly prohibit a worker from seeking or accepting work with another employer. You can think of this as, your traditional non-compete, right? The language that says you will not directly or indirectly work in the same or substantially similar industry, blah, blah, blah. We've seen those terms ad nauseum in our work. The next prong, right, is the penalized prong. What serves to penalize a worker for competing in their industry of choice? Penalize applies to the terms and conditions that require a worker to pay a penalty for seeking or accepting work, right? You should think about a pay-to-play type agreements, liquidated damages agreements. You see these a lot in healthcare contracts with doctors or partnership agreements where an individual might be able to pay $75,000, $100,000 back into the partnership or to the practice to essentially buy themselves out of their restricted covenants and their non-competes so that they can continue on with their work in the same geographic area. So that's the penalized prong. And then finally, we move to this third prong, which I think has probably given people the most heartburn out of all of this. And it's that functions to prevent, and it applies to terms and conditions that restrain such a large scope of activity that they essentially function to prevent a worker from being able to accept work with a new employer. As we'll discuss shortly and at considerable length today, this prong, the reason it causes people so much angst is because individuals and companies are worried that it can be used potentially to try and sweep other types of agreements beyond just a traditional non-compete, things like customer non-solicit agreements, NDAs, and things of that nature into the scope of the FTC's rule. So that the fear again is that the FTC and certainly employees trying to get out of their agreements will use this function to prevent prong to take aim at other restricted covenants that employers have relied on over the years to protect their interests. So going back, what else does the rule do? All right, so that's the clause, that's the language of the rule. What else does the rule do? It voids existing non-compete clauses. Once it's effective in September, it voids existing non-compete clauses for all workers that aren't considered senior executives as of the effective date. We're going to talk, don't worry, we're going to talk at length today too about what constitutes a senior executive. And then it also requires, well, before we get to that, so it voids all non-competes with workers other than senior executives. But after the effective date under the rule, you won't be able to enter into non-competes with senior executives anyways. Again, another contradiction among many that are included in the rule and its guidance. Old non-compete agreements will be fine with regard to senior executives, but you won't be able to enter into them and use them in the future following the September 4th effective date. So finally, the rule is going to require you as employers to provide a clear and conspicuous notice to workers that they are no longer subject to an enforceable non-compete. And this notice is going to have to be sent prior to the effective date in September to your workers. There is some upside here. The original proposed rule that the FTC put out last year before the notice and comment period required employers to have individualized communications with each and every worker, past and present, that was under an active non-compete. Obviously, this would have been incredibly onerous, burdensome, and expensive to you guys and to employers in general. And thankfully, the final rule allows you to send a mass communication to employees, past and present. And so it can be an email, it can be a text message. It doesn't have to be even a hard copy notice. So that provides a much easier avenue to achieve compliance here than what was originally contemplated by the FTC. All right, and if you look down at that last point on this slide, as I kind of mentioned, and as we'll discuss more today, the rule, at least in my experience, as is typical of many government writings, contains significant vagaries and apparent contradictions. And the FTC commentary appears to possibly even acknowledge this and states numerous times that whether a specific clause indeed constitutes a non-compete provision will depend on the precise language of that contractual provision and will also need to be decided on a case-by-case basis. As I'll discuss here later, I think that while it sounds bad for an employer, I think it actually is good for you, and it gives us some leeway to try to use other types of agreements to shore up the gap that's going to be caused by a non-compete ban if in fact the rule stands.
Yeah, and so thanks for that overview, Brodie, and thanks everybody for joining us. Before we got into some of the particularities or the nuance of the FTC's rule, we thought it was a good idea to sort of set the scene here for everyone as to how we got here with this FTC rule. So historically, non-competes have been a part of employment agreements for hundreds of years, and with some exception, most courts and legislatures, either at the state or the federal level, have largely approved the use of non-compete agreements between employers and employees. The only limitation in most jurisdictions and for most courts is that the employer simply has to have some legitimate business interest for implementing the non-compete. So that's your confidential information, your trade secrets you're protecting, or some form of goodwill that you're protecting. And then the other limitation or condition for enforcing those non-competes are historically that the scope of the non-compete, both in duration and its reach or application, it just has to be reasonable. But in recent years, there's been a growing trend at the state level in particular to either limit or outright ban the use of employee non-compete agreements altogether. As of this year, there are 4 states, so California, Minnesota, North Dakota, and Oklahoma. They all ban the use of employee non-compete agreements, with a single exception for non-competes entered in connection with the sale of a business. A number of other states, as you'll see there on the chart, have adopted some form of a hybrid approach that treats non-competes differently, either based on the industry at issue, while many others, including Colorado, Massachusetts, Washington State, Illinois, and the District of Columbia, they all permit them subject to some strict limitations. But again, just referring to the chart there on the right-hand page of the slide, many, if not most of the states that restrict or limit the use of non-compete agreements, they generally do so by establishing some income threshold that a worker has to satisfy in order to be subject to an enforceable agreement. Okay, and so against this backdrop, this patchwork of state legislative and common law treatment, comes the FTC, so the federal government's regulatory foray into non-competes. And so how did the FTC get here? So the process really begins when an agency determines what they want to prioritize, and then they potentially propose a rule in that space. And in terms of the Biden administration and President Biden specifically, labor issues have been sort of at the forefront of his policies, even going back to when he was vice president. And so back in 2016, then Vice President Biden issued a government call to action to all of his executive branch agencies, asking them to look at ways in which they could use their power to improve labor conditions, further the interests of workers. Just a few months after that, and perhaps even foreshadowing what was to come, the FTC and Department of Justice jointly published a guidance around how the antitrust laws would apply to a range of labor-related competition issues. Now, if we fast forward to when President Biden assumed office in 2021, we see that labor issues still remain at the forefront of his priorities. Just a few months into his presidency, he issued an executive order on competition issues and highlighted, in particular, labor competition and worker mobility as important priorities for his administration. And he again called on all of the government to address those issues, which ultimately culminated in the FTC's proposed rule banning non-competes back in January of 2023. And generally how that process works the same for most agencies. They propose a rule for a period of notice and comment. And so essentially the agency proposed a rule declaring what they think they should do, which in this case was ban worker non-competes altogether. And then they invite comments from anyone about the proposal for a period of time. And in this instance, the FTC received more than 26,000 comments. And as we'll get into this later, just to highlight how important that comment process is that these agencies will, and they're in fact required to address a lot of the larger or more relevant comments that they receive when they propose a final rule. And the FTC did that here in the more than 500 pages of commentary that's attached to the final rule, which again, some of those comments, both on behalf of businesses and employers, more specifically, did result in some favorable changes to what became the final rule, and specifically some exceptions that were not included in the proposed rule. As Brodie mentioned earlier, the final rule is now scheduled to be published in the Federal Register May 7th, which means that barring a successful legal challenge, it will become effective on September 4th, which is coincidentally going to be 2 days after the Labor Day holiday.
All right. So what other types of agreements can we expect may be covered beyond just the traditional non-competes that we, or the types of agreements we typically think of as traditional non-competes? As we mentioned earlier, the rule operates to prohibit any contract where the language also functions to prohibit a worker from being able to seek and accept work. Those are the magic words we're working with here: seek and accept work with a new employer. And so the concern here, as I mentioned, is that that third prong of the rule is going to be used to sweep in a vast array of agreements beyond those traditional non-compete clauses that merely prohibit a worker from going and just taking a job with a competitor in your field. So the original proposed FTC rule contained language indicating that such agreements like customer and employee non-solicit agreements, confidentiality, non-disclosure agreements, common forfeiture for competition agreements, and things of that nature were going to be considered de facto non-competes and would indeed be considered unlawful. The final rule gave employers some reprieve, and the FTC settled on a softened stance in this regard. In the commentary, the FTC expressly states that the functions two prong does not categorically prohibit any type of restricted covenant agreements like NDAs or non-solicitation agreements. But if you remember, as I mentioned when we first started today, about the perils of government writings, a few paragraphs after this express declaration that non-solicits are fine to use, the NDAs are fine to employ, the FTC seemingly backtracks in the commentary and states that if an employer adopts a term or condition in the form of a non-solicit or other agreement that is, quote, so broad or onerous that it has the same function or effect as a traditional non-compete, then the clause will be unlawful. So how the FTC is going to approach this is about as clear as mud. And again, that's something we've come to expect, both with the FTC and in some other arenas too surrounding this topic. So in just a little bit, I'm going to talk with you about how to structure non-solicits going forward in a way that gives you the best chance to successfully utilize those in lieu of non-competes if the final rule ends up standing following disposition of the various legal challenges. But for now, let's look at some of these other types of agreements you'll see on the slide that we believe may end up being swept into the rules under the ban. So forfeiture for competition agreements, we talked about that earlier. That's the type of agreements where you've provided some form of compensation to an employee, but it's contingent on them not going to work for a competitor in their field, and either they have to pay back something or they don't receive some form of compensation if they breach the agreement. This is if you read the FTC guidance, and I don't expect many of you to have sat down last Friday night with a nice glass of wine and read this thing. I mean, here's what we're looking at here. You're looking at the rule plus almost 600 pages of guidance. So I hope you didn't subject yourself to that. But if you read throughout this thing, those type of agreements are going to be deemed to penalize a worker and thus be unlawful under the FTC's rule. Things like bonus repayment agreements. Again, it's the great lawyer answer here. The answer is it covered by the rule? Well, maybe. It depends, right? So they're not typically going to be covered. It appears under the guidance here when the agreement requires repayment of a loan amount no more than what was lent to the employee in the first place. But if the repayment obligation is tied to competition and exceeds that initial payment, it likely could be swept in to the rules ambit and be considered to be a non-compete agreement. Severance agreements in the last probably 10 years has become very typical to include non-compete clauses and severance agreements, especially with high-level workers or workers who had significant customer-facing relations and access to company trade secrets, who were expecting to receive, golden parachutes or balloon payments or even just substantial compensation on the way out the door. The idea was that you would pay them the substantial compensation and it was worth it because you were going to buy back some time before they could start competing with you in your industry. That's, again, the FTC has decided that is also going to penalize a worker, and those won't be allowed at all. Equity arrangements, obviously this is going to be a big blow to you guys on the corporate side. Obviously, when you are attracting C-suite executives or other high-value workers, sophisticated personnel, it's very common, right, to offer equity, increased options for purchasing into the company in exchange to induce them to join your organization. Obviously, if you are going to give someone a portion of ownership, you want to have some assurances that they aren't going to take that ownership stake and then run off to your competitor across the street. And so, again, it's traditional to include non-competes among various restricted covenants in those equity agreements. The FTC does not care that you think that you have legitimate business interests that should be protected if you're going to offer someone equity. And so things like springing non-competes and non-competes arising out of repurchase rights or mandatory stock redemption clauses in agreement in these type of equity agreements are going to be non-competes that are now void and banned under the FTC's rule. They won't be considered exempt under the sale of a business exception to the rule that Drew is going to discuss with you here in a little bit. And again, we fully expect, and we have been getting, and we fully expect to continue to receive many questions and comments from our clients about what they can do now when trying to offer equity to potential high-value employees as compensation or otherwise. So we'll remain ready to talk those through with you and realize that that's a big issue for you guys. So garden leave arrangements. I see in the comments here, one attendee has asked, can you pay an employee not to work during a period of time and then choose later to not pay them and allow them to go work in lieu of a non-compete? That's what the FTC, if you follow your kind of paint by numbers garden leave arrangement, that would be something you could do. And for those of you who are not familiar, they use these a lot in the Northeast. They use these a lot in the EU and other places in Europe. It's where you have someone who's no longer going to be working actively for you, but you keep them on the payroll. You can pay them a pro rata portion of their original compensation. And if that's the case, you can still have a non-compete with them while they're receiving that compensation. The FTC points out that the rule only governs non-competes after the term of employment has ended. So technically, under a garden leave arrangement, your employment would not have ended. Even and the FTC acknowledges that you're allowed to cut back their duties. They don't actually have to be doing anything for you. And you can pay them to essentially sit on the sidelines for a period of time. Again, that's a much more expensive endeavor than what we do right now when we just have people sign non-competes. So it's probably not feasible to do for all of your employees. It would be something you would probably need to target, like I said, high value workers, people that really have had access to your trade secret information, and use it in those particular circumstances.
So the way we've sort of tried to structure this is the way generally you're going to want to think about these issues if the rule ultimately becomes effective. And so, the first question you're asking is this term or condition or, specific provision or agreement, is it a non-compete clause under this final rule? And so once you've made that determination and you say, okay, this is a non-compete clause under the final rule, the next question you should be asking is, okay, what does the rule say that I, as an employer or as a business, cannot do with that term or condition? Well, for workers who are not senior executives, both of which are defined terms in the rule, the final rule says that it's an unfair method of competition for a person to enter into or attempt to enter into a non-compete clause. So no new non-competes after the effective date. It's also an unfair method of competition for you to enforce or attempt to enforce a non-compete clause. There's one exception for causes of action for violating the non-competes that accrued prior to the effective date, which we're going to discuss in a little more detail later. And this could even, enforcing or attempting to enforce could even be something as simple as sending a cease and desist letter to an employee. And then the last thing you're prohibited from doing is going to be to representing that the worker is subject to a non-compete clause. For example, this will prevent you after the effective date from sending a cease and desist letter to a former employee's new employer to say, look, they're bound by a non-compete. Here it is, it's valid, you can't employ them or they can't do these things. And now, with that in mind, I think it's important to note just how broad the term workers is defined in the rule. It's defined to include, of course, employees, but also independent contractors. And then if you'll look again at the guidance or the commentary there regarding the workers definition, they essentially ask the same question in determining whether someone is going to be considered a worker. It's, does the person provide a service for the entity that's asking or who's had them sign a non-compete? If they are providing a service, they're considered a worker under the rule. But the term, one point of clarification there is that the term worker in the definition refers to a natural person. So the FTC rule here is not going to impact business to business non-competes unless we're talking about a non-compete with a sole proprietorship. And then secondly, the rule does provide a limited grandfathering for non-competes executed prior to the effective date for workers who are deemed senior executives under the rule. So again, if a non-compete is executed before the effective date, even between now and that September 4th date, you're not prohibited from enforcing or attempting to enforce it. But the scope of this grandfathering for senior executives is going to be extremely limited. And just to give you an idea as to how limited the scope is going to be, in some of the commentary, the FTC estimated that about 30 million non-compete agreements for workers exist in the United States. But in that same commentary, when they were discussing the senior executive grandfathering, they stated an estimate, or their estimate was just that 0.75% of workers who are bound by non-competes will be covered by the exception. So that's 225,000 agreements out of 30 million total. Okay, and so under the rule, a senior executive is going to be a person who, first of all, they have to have annual compensation of at least this approximately $151,000 in the last 12 months. So the preceding year leading up to when they executed the non-compete. The FTC explained that they set this threshold as it was the 85th percentile of earnings for full-time salaried workers nationally. And they explained that the salary component can include more than just the salary. It could also include commissions that were paid to the worker, non-discretionary bonuses, and a few other non-discretionary payments. But the most important piece or criteria for the senior executive carve-out is going to be the second part, and it's the requirement that the person has to be in, quote, a policy-making position. And so before I get into the specifics of that, I think it's important to give some of the background or explanation that the FTC gave for why it was grandfathering the pre-existing non-competes with senior executives. The FTC explained that the carve-out exists because the concerns they have about worker non-competes in general, that they're exploitative and they're coercive, they don't exist for senior executives. Based on the idea that they have their more comparable bargaining power with the employer or the entity who's having them sign the non-compete. Okay. And so that commentary, though, suggests that whether a person's in a policy-making position under the rule is going to be measured at the time that the non-compete was executed, and not, their particular authority when you go to try and enforce the non-compete or just before the end of their employment. And the final rule defines those in a policy-making position to include the entity's president, their chief executive officer, or an equivalent position, or others with what they call policy-making authority, which in turn means the final authority to make policy decisions that control significant aspects of a business entity or common enterprise. In other words, the FTC's made clear that this is going to be limited to folks in C-suite or equivalent roles. And the definition under the FTC's rule of senior executive is more limited than some of you who work with or advise or work for companies that are going to be covered by the SEC's definition of executive officer under Rule 3B7 of the Securities Exchange Act. So Rule 3B7's definition contains an additional category other than these president or C-suite level employees for any vice president or someone in charge of a business unit, division, or function. Those folks would not be covered by the FTC's rule. In fact, the FTC's rule specifically states that senior executives don't include folks who advise or merely exert influence over policy. But again, they have to have final authority or final say over those issues. The commentary also notes that officers or subsidiaries or affiliates generally are not going to satisfy this criteria unless their authority is over the entire common enterprise and not just a particular division or unit. So for example, if you have an executive who's the president, let's say, of a subsidiary that accounts for maybe 10% of the revenues of a larger entity, then you're most likely going to be able to bind that employee to a non-compete with respect to the larger entity. I mean, I think, in telling you all these things, it's important to note that the definitions that the FTC's used in these rules, like some of the other ones Brodie already hit on with the scope of the non-compete clause, they're incredibly vague. They leave significant room for interpretation, which is going to lead to practical and legal challenges to the rule's applicability if it does become effective. But another thing that we'll talk about later too is the ambiguities here may also be something you can use as a sword if the rule becomes effective, when we talk about this good faith exception here in a bit. Just moving on now to probably one of the most asked about components of the rule is this idea of a sale of business exception to the non-compete rule. And so like all of the states that we talked about earlier that ban non-competes, the FTC's rule has a carve out for sale-based non-compete clauses when the clause is, quote, entered into by a person pursuant to a bona fide sale of a business entity, of the person's ownership interest in a business entity, or all of or substantially all of an entity's operating assets. So let's say Company A purchases an operating division of Company B. The deal looks a lot less attractive if the president of the operating division that was sold to Company A could terminate their employment the day after the deal closed, and then start a new business doing the exact same thing the operating division sold to Company A. Well, the FTC's proposed rule would have allowed the president to do that here if they owned less than 25% of the entity that was sold to the buyer. But thankfully, the FTC's final rule eliminated the ownership threshold here and noted that his decision to do so was actually based on some persuasive arguments that commoners made, which many of you probably expressed internally, if not through a comment as well, was that the ownership threshold fails to take into account the fact that their employees with much lower ownership interests, or members with much lower ownership interests, or partners with much lower ownership interests that have significant goodwill in the business, and so they too should be able to be bound by this exception. In the preamble to the final rule, the FTC stated that a bona fide sale is one that's made in good faith, as opposed to, for example, a transaction whose sole purpose is to evade the final rule. And then the FTC further explained that it'd be a bona fide sale of a business where a business is sold to an unrelated third party for fair market value. And so in that regard, the FTC then went on to very specifically explain that this exception does not apply to, as Brodie mentioned earlier, repurchase rights or mandatory stock redemption programs. And so, a lot of times with private companies specifically, if an employee, their employment's terminated for whatever reason, there's generally a right to repurchase the equity that they hold, whether it's incentive equity, rolled over equity, or whatever kind it might be. And a lot of times, obviously, those agreements will include a non-compete that says the non-compete applies when the equity is repurchased and for a period of time thereafter when the repurchase is effected. So in theory, this could be considered a sale of business because the person's technically selling their ownership interests. But the FTC actually in the commentary lumped these transactions in with springing non-competes and characterized them as sham transactions and evasion schemes. So the FTC clarified that those types of agreements don't qualify for the bona fide sale of a business exception. And the explanation they gave is because in each of those cases, the worker, at least in the FTC's view, is not exactly exchanging goodwill for the non-compete or knowledge, and they also lacked knowledge or the ability to negotiate the terms or conditions of the sale at the time of contracting. And on that same point, the FTC also has taken the position that sham transactions between wholly owned subsidiaries are also not bona fide sales because they're not made between two independent parties. Again, just like the senior executive carve-out we just talked about, there are a number of open questions here regarding what would and wouldn't work. For example, a question that's come up is whether an employee who has phantom equity as opposed to actual ownership shares or real equity, and based on the way the exception's written in the regulation, there could be an argument both ways. Technically, phantom equity, just by its name alone, is technically not an ownership interest per se. However, it does mimic ownership in that the person largely obtains the same benefits of ownership without diluting others' actual ownership interests. So I could see an argument for crafting phantom equity arrangements in a way that satisfies the exception, as long as it's something that is vested and that the person's actually receiving a return on and negotiated themselves. Again, you just need to ensure in those situations that your non-compete is a condition to the transaction and is also agreed to as a part of the overall transaction where the person's issued or purchases that phantom equity. And so one other piece to keep in mind, though, before I move on to the good faith exception is that, even if your agreement qualifies for the sale of a business exception under the FTC's rule, that doesn't necessarily mean you're free and clear to impose whatever restrictions you want. The agreement would still have to pass muster under state law. So, even if this FTC rule becomes effective, you're still going to have to look to the applicable state's law to ensure your agreement is going to be enforceable there as well. Now, one of the maybe less discussed, but I think critical components of the rule that is actually favorable for businesses is this idea of a good faith exception. The rule has an exception for scenarios where a business enforces or attempts to enforce or makes representations about a non-compete where they have a, quote, good faith basis for believing that the FTC's rule does not apply to the situation. And the rule and commentary don't explain specifically what sort of showing an employer has to make to satisfy this standard, but businesses should be able to rely on the exception if they're forced to defend claims in the future if the rule becomes effective. So a couple of scenarios. For example, business could rely on the exception if they truly have a good faith belief that your agreement qualifies for the bona fide sale of business exception, such as the phantom equity situation we just talked about. Businesses might rely on the exception when they're self-determining whether a worker qualifies as a senior executive, which would potentially, alleviate your obligation to notify them about the unenforceability of the existing non-compete or whether the existing non-compete is going to even remain valid after the effective date. You might also rely on the safe harbor here if they attempt to, if you attempt to enforce a pre-existing non-compete against a worker who, in, again, good faith, you believe to be a senior executive, only to be told later that they don't qualify for that exception. And finally, you should be able to rely on this exception when you consider whether a term or condition other than your standard non-compete, so your non-solicits, NDAs that Brodie talked about earlier, function as a non-compete. So with that, I'll turn it back over to you, Brodie.
All right. So real quickly, I realize I'm conscious of the time and that you guys may be on a tight leash here with it being the lunch hour. So some of these slides we'll cruise through a little quicker to get to the FAQs and some of the action items for next steps that I know you really want to hear about. But I do want you to realize that there are some groups that are exempt from this final rule. I know that my colleagues who deal a lot with franchise law were ecstatic to see that they were still allowed to include non-competes in their franchise agreements. So the franchise can still include the provisions in a franchise agreement with the franchisee to protect the system as a whole. But what they can't do is have those provisions in an employment agreement, either with the employees of the franchisor or the individual employees of the franchisee. So, McDonald's can have non-competes with its franchise, but corporate employees still wouldn't be able to have them in their contracts, nor would obviously the cashiers at the individual restaurant, which kind of makes sense. So persons or entities outside of the FTC's jurisdiction obviously are not parties to this rule either. This would include nonprofit corporations, banks, savings and loans institutions, credit unions, common carriers, and several others that the FTC's Enabling Act doesn't apply to anyways. The important thing to note here is that tax exempt status of an organization alone is not going to be determinative of whether or not the organization is a nonprofit for purposes of the ban. The commentary explains that they're going to apply, the FTC is going to apply a two-part test to determine whether the entity is indeed exempt as a nonprofit. And you can go back and look at that test here in our slide deck. Notice requirements, as I mentioned earlier today, if the rule stands or if we get to the effective date before an injunction is entered or other action is taken by the court, you are going to have to issue a notice to all workers past or present that still have an active non-compete. That's the operative word there, active, not If it's lapsed, you don't have to do anything with regard to that individual. But this will be a notice that goes out to all non-senior executive workers, informing them that their non-compete agreements are no longer effective and will not be enforced against them. Again, it doesn't have to be an individualized notice under this final rule. Mass communication can be used, text message, emails, letters, whatever you like. It should be in writing, though. And the main point I want to make here, though, is that it's worth noting that the final rule exempts employers from the notice requirements where the employee has no record of the street address, email address, or other contact information for the worker. This was a concern. Many comments were submitted by both businesses and the chambers around the country about the burden that would be placed on employers trying to notify former workers. I mean, we all know that that worker contact information can go out of date really fast, and it was giving employers considerable anxiety to think that they might still be on the hook for some kind of culpability if they didn't inform a former worker, even though they didn't have the contact information for that employee. So that's something you don't have to worry about now. And finally, the FTC, as you'll see here on this slide, the FTC provided some safe harbor model language for the notice. They've got a stock notice that they provided as part of their guidance to the final rule. The stock notice is here on this slide too. You can go back and refer to, or you can find it at section 910.2, section B3 of the guidance that accompanied the final rule when it was issued last week. All right, so finally getting to some of the good stuff here. A question that's on everybody's minds: what impact does the final rule have on currently pending or anticipated non-compete litigation? Employees it's becoming apparent that employees are likely to try to rely on this rule and the accompanying 600 plus pages of guidance from the FTC to already start to try to defend against suits related to non-competes in this interim term before it becomes effective. In the past few weeks alone, I've had multiple attorneys for employees tout the ban in response to cease and desist letters I've sent on behalf of clients. And beyond just reminding these hopeful attorneys that the rule is not yet effective and or that there is a strong likelihood the rule will be enjoined while the litigation plays out, it's important to be aware that the rule itself contains the express carve-out for non-compete litigation where a cause of action accrued prior to the effective date of the rule. I don't think many people realize that, but there is a carve-out that says, look, if someone has violated a non-compete, non-competes are still valid right now. If someone has violated that or does violate that prior to 9/4 when it becomes effective, you have the right to file suit and protect your legitimate interests. So Drew and I's message to you is: do not sleep on your enforcement rights here. If you've got if a former employee is currently breaching their restricted covenants, their non-compete agreements, or threatening to breach them, now is your time to act, right? While you still can to reap the bargain for benefit of your non-compete agreements. So it's turned into somewhat of a race to the courthouse here, knowing that now that we do have an effective date, but at least it provides some clarity to your legal rights while we're in this holding pattern, waiting to see if the rule is enjoined, overturned, or becomes effective.
And just keeping with this litigation theme, I'm sure many of you have seen in the news, there's already been several challenges filed, 3 of which we're currently aware of. But the most important ones really to keep an eye on here is the Chamber of Commerce's case and then the Ryan LLC case, both of which are pending in federal court in Texas. In both of those cases, motions for preliminary injunction have already been filed, where those 2 parties are seeking to either stay or enjoin the FTC from enforcing the rule. And those 2 cases are proceeding in parallel with, again, those briefing schedules already in place, where we should expect to receive a decision in both cases by either late June or early July. So, which would give you, some leeway, a few, month plus grace period to, or I guess advance notice as to whether the rule is actually going to become effective. And just generally, each of the lawsuits offer similar grounds for challenging the rule, that the FTC lacked or exceeded its statutory authority to issue the rule. It's an unconstitutional delegation of legislative power, and that the rule is arbitrary and capricious. And so we just highlight this litigation so that you're mindful of the status of that litigation, because ultimately that'll determine whether or not you have to comply with the rule in the first place. Okay, and one of the other questions that you're probably either fielding or thinking about when you're getting ready for this rule, just because of how widespread news of the FTC's rules been, is questions from employees or workers that say, what happens to our non-compete agreements now? And so we prepared some proposed talking points here, and we do think it's recommended that you give similar uniform responses to employees while that litigation over the rule's validity is ongoing. And just moving now, since we're a little tight on time, Brodie, if you want to go into some of the more high-level FAQs that we wanted to answer for folks.
Absolutely. So the primary question we've gotten over the past week is what should you as employers be doing right now? And Drew just touched on this, talking about the Chambers case, but the important thing to remember is that the rule is not yet effective, and that the Chambers of Commerce in their case has argued, and I believe correctly so, that if the federal government wanted to regulate or ban non-competes, Congress, as the federal legislative body, was the appropriate branch to take that action. And so while I don't have a crystal ball, and I obviously can't make you any promises, I believe, and I think I can say collectively, we believe that the Chambers is likely probably to obtain an injunction while the litigation plays out. And in my opinion, I think it's probably a strong likelihood, as a commentator and someone who does this, that the FTC's rule is probably not going to stand ultimately, and at worst is going to be significantly pared back. Again, I can't make you that promise, but that's where I feel like this is going. But with that said, our advice right now is to not deviate from your current practices of having employees execute non-competes. We hate to have you forgo this opportunity to protect your interests, only to have the rule enjoined or ultimately overturned, and you have missed the opportunity to get those agreements in place. In doing that, we want you to ensure that your agreements have severability clauses with good language, that to make sure that your non-compete provisions are set out in distinctly severable sections from other restricted covenants or other substantive provisions that you want to remain. This will make it easier to sever offending non-compete provisions if the rule ultimately stands. I would consider tying certain enumerated aspects of a worker's compensation specifically to the non-compete, and adding a clawback provision for that piece of compensation that would relieve the company of obligation to either pay such a sum if the non-compete is ultimately rescinded because of the rule, or possibly giving the company the right to try to claw that back. And finally, now, as I'll discuss here in just a second, I think now is the time to also take a look at your other restricted covenants to make sure they're tailored in a way that gives you the best chance of having a court enforce them. They're going to have to carry a lot of the weight now that you may not be able to use your traditional non-compete. So in that vein, this is probably the second most asked question that I've received or we've received this week. And it's whether or not non-solicitation agreements can be utilized in the wake of this ban. And if so, how do you structure them, right? So we've already established that you can, or that the FTC contemplates a world where you can use non-solicits even if the rule stands. So how do you structure them? A well-drafted non-solicit is going to be your best alternative here. And so what you want to look at is how do you draft that, right? So my mantra to all of my clients is don't get greedy. Don't shoot for the most expansive clause. Don't utilize the most expansive definitions for terms imaginable. What you need to do is you need to identify your precise business interests that you want protected and draft language that protects those interests and goes no further. So this means cabining your non-solicit provisions only to the entity that the worker was employed by, not extending it to customers, employees of affiliates or subsidiaries. We see that all the time, right? We see the company and all of its affiliates and subsidiaries, and the courts are already now holding that renders certain provisions overbroad and unenforceable. And I think you'll certainly see that if this rule stands. Structuring it in a narrowly tailored way means limiting non-solicit clauses to the customers and employees the worker actually had material business contact with, or about whom they possessed confidential information or trade secrets while in your employ. On top of this, you should consider a limitation to just customers or employees the worker dealt with in a short period of time preceding their separation. I like to use 12 months. There's no hard and fast rule, but the more you can limit that, the more narrowly you can tailor this, the more eminently reasonable you look to courts that are not located in, say, California. And we encourage you to do that. Your non-solicit should not extend to prospective or former customers of your business, and it shouldn't even really extend to active customers of your organization that the worker, him or herself, never had any contact or dealings with. This, again, shouldn't come as a shock to many of you who are familiar with non-compete laws. Many jurisdictions in recent years around the country have already taken the position that those type of prohibitions don't protect legitimate business interests and shouldn't be enforced. So you should also take care that your non-solicit provisions target only active solicitation and don't attempt to prohibit the passive acceptance of work. You need to think of solicitation as being picking up the phone, calling your customers, calling your employees, trying to induce them to come over to their new organization and leave yours. It shouldn't be wielded as a broad weapon to prevent them from even servicing the customer if the customer voluntarily leaves you and comes to them. That likely could be considered so onerous that it turns this non-solicit into a non-compete under the FTC ban. And in some jurisdictions, you're going to have problems with that anyways under just regular state non-compete law. So admittedly, there's not a lot in the FTC's rule for employers to take solace in. However, one bright spot is that the FTC retreated from its original proposed stance, like I mentioned earlier, that non-solicits or NDAs and other like restricted covenants were de facto non-competes and unlawful. There's two things that are key in my mind in the guidance that should embolden you as a business to use non-solicits, whether the rule ultimately stands or not. The first being that if you look at the final rule on page 79, the FTC made clear that whether such clauses, meaning non-solicits, whether they, in non-competes, whether they constitute a de facto unlawful non-compete under the new rule, that is going to need to be adjudicated on a case-by-case basis, not reviewed, adjudicated, meaning the FTC is contemplating already that a court is going to need to be the one that decides whether or not something is still a non-compete. The rule also, the second piece of this is the rule also contains that good faith exception that Drew already mentioned, that states it's not an unfair method of competition for you to enforce or attempt to enforce a clause where you have a good faith basis to believe that it doesn't fall under the rule. So combining these two pieces of information together, you should feel comfortable both implementing narrowly tailored non-solicits and actively seeking to enforce them in lieu of a traditional non-compete, again, regardless of whether the FTC rule ultimately stands.
There's a slide here about penalties for non-compliance, but just in the interest of time, because all of that information is pretty exhaustive there, I want to move on to sort of our wrap up here with what employers should be doing now. So obviously the first thing, anytime there's a new law governing your business, whether it be a workplace law or something else, is let's make sure we're even covered by the law. And so, accepted from the FTC's jurisdiction are banks, savings and loan institutions, air carriers, or true nonprofits, So if that's the case, you don't have to worry about the FTC rule affecting your business. Although I will note that in terms of banks, the FDIC did this past month publish proposed revisions to its policy on merger reviews, essentially saying or proposing that it's going to, moving forward, generally require that the selling institution either enters into or non-compete agreements with employees of a divested entity, nor enforce any existing ones with any of them. But so that's just to say that, keep an eye on the bigger picture here in this growing movement at more than just the FTC attacking non-competes. It's the NLRB who's been challenging them. Now the FDIC and obviously the state legislatures as well. And just to move quickly through this, I mean, one of the more important things you should be doing now to prepare for the chance that the rule becomes effective is just audit your existing non-competes. That's for current and former employees who are still under an active non-compete. Figure out which ones are going to be deemed a senior executive, which ones would satisfy that criteria, and so you don't have to give them notice under the rule. You also need to identify employees that would satisfy the senior executive criteria for the fact that, if you don't have an agreement in place with them, you might want to try to do that before the effective date, because if it does become effective, you'll be grandfathered in. And then obviously, to piggyback on some of the things Brodie said is, identify your other restrictions like your NDAs, your customer and employee non-solicits, your bonus repayment programs. Figure out which ones are sufficient as currently drafted that you think in your mind will protect your legitimate business interests in the event the rule is effective. And then for other ones, make sure they're not so broad, to Brodie's other point, that they're actually going to be enforceable. Because if they are so broad that they function to prevent this person from working in a competitive position, then the FTC's rule is going to consider them non-competes, and you're going to end up not being able to protect solicitation of your customers or your confidential information. And then I'll pass it over to Brodie now to wrap us up.
Yeah. And we'll close this out here shortly. I realize we're short on time. I did want to mention, if you go back and look at this slide, you can look at the last slide later, but I would like to encourage you to shore up your policies related to the confidentiality of your trade secret information. I mean, if we're being honest, protection of that information is the ultimate goal with the use of any non-compete, right? And if you shore it up and bolster your policies related to trade secret protection, it's going to lessen the blow felt by losing non-compete agreements if that's actually what comes to pass. So take this time to really dive into your policies. If you don't have them already, implement a framework for archiving employee computer system activity and email accounts. Look into investing in robust security products that monitor employee activity related to accessing information. Turn off printing capabilities where feasible, and take those kind of actions. Drew and I recently obtained a resounding victory for a client in federal court where the non-compete was a no-go for us. We couldn't use it, but the company had a stellar confidentiality agreement and robust security products that caught the departing employee's misappropriation activities. And it made it impossible for him and his new employer to avoid the potential for significant liability under various trade secret statutes. So in the end, because of the client's dedication to securing their information, we were ultimately able to achieve the same goals that we would have been going after using a non-compete agreement. The departing employee was ultimately fired, and both he and the new employer agreed to not solicit our clients for a certain period of time, effectively creating a non-compete type atmosphere. So this new strategy could become, this type of strategy could become the new norm, right? If the ban somehow survives the legal challenges facing it. I realize we've gone over a little bit. I want to thank every one of you for coming. We have our email addresses are now on the screen. Please feel free to contact us. I know we couldn't get to everybody's questions today. I really wanted to send us those questions. Give us a call. We'd love to talk to you. If you want a copy of the deck, please email me and I'll make sure that gets to you. But again, we're here to serve you guys. You let us know what your questions are and we'll run them down. Thank you for coming today.